We've all just heard and received the ruling by the Speaker of the National Assembly on the admissibility or permissibility of a motion to effect cuts to the budget. Your viewers would recall that this matter was the subject of extensive debate last evening in the National Assembly, during the course of which very cogent and persuasive and comprehensive arguments were offered by a number of speakers on the government side. The distinguished Attorney General was foremost amongst the government speakers, but a number of other persons spoke and articulated supportive arguments as well. Your viewers would also recall that this matter was the subject of detailed consideration in the courts of Guyana, and emerging out of which was a very clear and explicit decision handed down in a written ruling by the Honourable Chief Justice. What we have today is a decision by the Speaker that collides with the decision previously handed down by the court. And to us in government, this is an extremely alarming development. One would have thought that the decision by the courts would have been regarded as authoritative, and in that regard, in fact, a recommittal of the matter, as occurred last evening, perhaps should not even have been entertained. Be that as it may, the debate having been entertained, one would have expected that the compelling and authoritative status of the court ruling would have been respected. Like I said, this is a development of very significant concern and alarm to the government. We will, of course, be studying its implications, particularly from a legal standpoint, and we will determine the course of action that we will follow, depending on what emerges from our consideration of the issue. But it is a very, very troubling and alarming development.
Thank you very much. As the Honourable Minister of Finance indicated, we have just listened to a very long ruling rendered by the Honourable Speaker, the content of which I have been unable to subject to any copious and studious analysis. But having listened to the Speaker read out the ruling, I feel vindicated that we have a series of conceptual difficulties with fundamental concepts in relation to our Constitution and the different role and functions which are to be performed by important organs within the Constitution. We had the very strange and unprecedented exposition last night of being invited to essentially review a decision of a court, knowing full well that the rulings emanating from the court on matters of law and on matters of interpretation of the Constitution are final, and therefore it is simply not open to any other agency in the constitutional construct of our legal system to essentially, in an institutionalized way, offer an opinion that would be binding, that is in conflict with a ruling of the court. And that is what you have here. The court having ruled. Now, if the court did not rule on the matter, then I suppose it is open for any authority to seek to offer their viewpoint on any given legal matter. But once there is a ruling of the court, whether that ruling be regarded as preliminary or not, that pronouncement emanating from the court is the authoritative declaration and conclusive determination of that matter, and it is simply not open to any other agency to in an institutionalized way, express an opinion and then act upon that opinion that is inconsistent with the code. So you have that problem, which is further compounded by the fact that the litigation is still ongoing, and there is a well-known rule, and it is captured in the standing orders of our Parliament, that when a matter is sub judice, meaning that it is the subject of legal proceedings, it should not be the subject of discussion, more so a ruling from the Parliament, which ruling is inconsistent with the pronouncement made by the court. So you have a collision of many concepts here, and like the Honorable Minister of Finance, the government will have to cogitate on the matter and chart the way forward. Suffice it to say that I have already written to the Honorable Chief Justice requesting that the matter be reconvened and that a final ruling be made, I suppose after hearing further arguments if that is deemed to be necessary. But you will have another, I anticipate, let us assume for example that the Chief Justice is to rule or to confirm his preliminary ruling in a final ruling. What will we have in the country? You will have a Parliament saying that they can make final declaration on matters of law, and you have the judiciary saying that they can make final declarations on matters of law. So you have a collision of concepts by the various institutions and organs of the state, either misinterpreting or rightfully interpreting their respective roles and functions. That is the difficulty you have. Assuming that the Chief Justice is to reconvene and confirm his preliminary ruling, we would be faced with a conundrum that we would experience great difficulties in extricating ourselves from as a country and as a government, and I am sure as a Parliament collectively. And that is the difficulty that we face when we don't understand our roles conceptually